Hello and welcome back to Legal Information, Law Insights. I'm Advocate Mukund Mahajan, and today, here to break down complex legal topics into easy-to-understand explanations. Today, we'll explore partition suits in family law. If you are dealing with family property disputes, this video will guide you through the legal framework and procedures involved. Now, let's understand what a partition suit is. A partition suit is a legal remedy available when co-owners of a property wish to divide their jointly held property. It's a common scenario in families where property is inherited or owned by multiple members, leading to disputes about its usage or ownership. The suit allows the court to divide the property fairly, ensuring each party receives their rightful share. Now, let's discuss the grounds for filing a partition suit. Disagreement among co-owners. This occurs when family members or co-owners cannot agree on how to manage or divide the property. Disputes may arise over the use, sale, or maintenance of the property, leading to the need for a formal division. Desire for separate possession. When one co-owner wishes to independently possess their share of the property, they may file a partition suit. This is often the case when co-owners want to separate their share from the rest of the property to use or manage it individually. Inheritance disputes. These arise when there are disagreements among the heirs following the death of the property owner. If the deceased owner left an undivided property or if there is a dispute over the rightful share of each heir, a partition suit can help resolve these issues. Now, we will learn about the legal provisions governing partition suits. Several laws govern partition suits, depending on the nature of the property and the community involved. First is the Code of Civil Procedure, 1908, CPC, which provides the procedural framework for filing and adjudicating partition suits. The suit is filed in the civil court where the property is located, and the court issues preliminary and final decrees based on the case's specifics. Second is the Hindu Succession Act, 1956, which governs partition among Hindus, especially for ancestral property. It defines the rights of co-parceners, co-owners, and the distribution of property among heirs. Third is the Indian Succession Act, 1925, which is applicable to Christians, Parsis, and others. This act governs the rules of intestate succession, influencing how property is divided when a person dies without a will. Fourth is the Muslim Personal Law, Shariat, Application Act, 1937, which governs partition matters among Muslims based on personal laws, with specific rules on how property is divided among heirs. Fourth is the Transfer of Property Act, 1882, which provides provisions related to the transfer and partition of immovable property, crucial in understanding ownership rights. Fifth is the Special Relief Act, 1963, which offers declaratory relief in cases where property rights need to be established, sometimes relevant in partition disputes. Sixth is the Real Estate, Regulation and Development Act, 2016, RERA. Although primarily for real estate regulation, it can influence partition cases involving properties under development. Other state-specific laws. Various states in India have specific laws or amendments that may affect partition suits. For example, the Maharashtra Land Revenue Code, 1966, deals with land revenue and property partition in Maharashtra. Now, we will understand the process of filing a partition suit. First process is filing a suit. The process starts by filing a suit in the civil court where the property is located. The second process is court's examination. The court examines documents to determine the rightful shares of co-owners. The third process is preliminary decree. A preliminary decree is issued, declaring the shares of each co-owner. The last process is final decree. If the co-owners cannot agree on the division, the court appoints a commissioner to physically divide the property, leading to a final decree. Now, we will explore the different types of partition. First type of partition is partition by mutual agreement. Co-owners agree on the division without court intervention. Second type of partition is partition by judicial decree. The court intervenes to ensure a fair division when mutual agreement is not possible. Now, we will discuss the challenges and considerations in partition suits. Partition suits can be complex due to several key factors. 1. Proving ownership. One of the first challenges is proving ownership. It's essential to have proper documentation, such as title deeds, sale agreements, or inheritance papers, to establish who legally owns the property. 2. Valuation of property. Accurate valuation of the property is crucial for ensuring a fair division. Without an unbiased assessment, it's difficult to divide the property equitably among the parties involved. 3. Possession issues. Ensuring that each party can take possession of their respective share without conflict is another hurdle. Disputes often arise over who gets what portion and how it will be physically divided. Partition suits involve careful consideration of ownership documentation, property valuation, and resolving possession disputes to ensure a smooth and fair division of assets. In conclusion, partition suits are essential for resolving property disputes among co-owners. They involve various laws and can be intricate, making it crucial to seek legal counsel. If you are facing a property dispute, consult a legal expert to understand your rights and navigate the process effectively. Thank you for watching Legal Information, Law Insights. Don't forget to like, share, and subscribe for more legal insights. If you have any questions or topics you'd like us to cover, leave them in the comments below. Until next time, stay informed and empowered.